Good day, fellow South Africans. We are just going to be doing today. We are just only going to be responding to the judgment by the Honorable Mangu Lockwood J. And in so doing, I will quickly take you to the business of the day. And the business of the day, which I will send to the court today, as you are looking at me doing it, and how I do it is exactly that. So, without any further ado, understand it to be true that I love music, and I'm very particular in my choice of music. So here is the court order. Who's this one? Alright, this is the court order by the Honorable Mangu Lockwood to case number 19275, and you can see it, there it is. And I have told you yesterday that the case number is this one. It is a case number that exists on Lieutenant Commander Mangolele's name as the plaintiff, and then not as the applicant. And then the state in this regard is the first defendant, and then the Minister of Defense in this one is the first respondent. So immediately we have a discourse in that particular regard, and then having that particular discourse, this is the judge that has misrepresented this. It's her name there, and then it's basically her signature in that particular instance. So I am setting down this matter by explicitly putting forth the following terms, as you can see here. The Deputy Judge President or Judge President of the Upper Guardian of the Children's Rights, in terms of Section 33 of the Constitution, read with Section 18 of the Superior Courts Act and Section 64 of the Children's Act, requested to direct a full bench to on a date that will be provided by the Deputy Judge President or the Judge President of the Upper Guardian of the Children's Rights, preside on the matter in terms of Rule 612A of the Uniform Rule of Court under the following circumstances. Remembering that Batupele principles includes redress, and when the judiciary applies Ubuntu as a constitutional value, the Deputy Judge President or Judge President are humbly requested to direct a full bench to review administrative action adversely affecting the human dignity of the plaintiff, to provide as a father to Nyiko Mangolele, 15-year-old son, and Aluta Songelwa, 2-year-old daughter. Provide as head of the Mangolele family a son to the 83-year-old Leta Kukunana Majila, and what blocks the plaintiff payment of salary is explained in this 4-minute and 7-second available in the following video link. By simply looking at the video, any person would know the actual problem to be solved, and the plaintiff would not come to court if this problem did not exist. Now, instead of solving the problem, effort is placed on persecuting or oppressing the plaintiff only to sustain corruption criminal activity, apartheid or discrimination or misconduct. And without any further ado, because I am live and then I am doing this thing, can simply click on this particular link and follow it. See what transpires in that particular link.
Okay, I'm going to quickly give you a quick short brief as to what exactly is stopping my salary. To simplify this to you, the door that currently locks payment of my salary is what the DoD PESOL system says, and then in that particular regard, this is what the DoD PESOL system says. It says application, this is a DoD PESOL system talking about Mangolele and then discharge and then type of termination. It's a 6 application reason, offensive behavior, that is that, and then it was done on 8 August 2018 and then by Mr. Marcel Divet. He used this particular authority. This is what you will find each and every time you visit the DoD PESOL system in relation to 99004046 MC Lieutenant Commander Mangolele. And then to then come to this particular reality, you come to an issue where you have to be as realistic as possible in relation to you go to what exactly is section 105 saying. When you look at the reason for discharge, it is presented as section 105, not Vice Admiral Samuel Hlongwane, but section 105. So we go and look what section 105 says. When we get to what section 105 says, we find that section 105 talks about offensive behavior, and then this is what needs to happen in offensive behavior. There must be a conviction. A conviction is the key word in this particular regard. The conviction, how does it happen? Hey, Mangolele must have been in court and then he must have been the accused, and then this is what must have happened. You will pause this thing and read it out loud for you to understand it during the course of after the live shooting of the video, which is just only minimized. And then after that particular reality, you come back to my actual reality and ask which prison held me for 5 years or less. You understand? And then which court sentenced me and where and when. And where is the record of the military review of the court findings? Because for any guilty verdict in military court, there is always a review. Always. It is statutory. It is like that. That is when you serve and defend in accordance with the Constitution and the law. Your findings as Chief of the Defense Force shall cause you to pay my salary and deal with the constitutional obligations imposed for such gross misconduct. We must go forward, General Mapwanya, and my family must not suffer anymore. Stop ignoring my reality and praying that I must support criminal activity, corruption, apartheid, and misconduct. I am the Defense Force. I am against corruption. I do not do corruption. Don't force me into it. Don't force me to come and sign for pension and then such that we have a corruption being supported by Mangolele, who openly, knowingly so that he has signed for his pension knowing that it was unlawful. He has never stood any trial for offensive behavior. I ask you to respect my fundamental human rights. Please. God bless you. Bye-bye.
So that is what transpires when it comes to this particular reality. And sorry for that. And that is exactly what this link entails, that is what any judge will know. You understand, and I want you to understand this reality, because it is the reality that is required in a professional conduct, where you say, you gave me a link. What is in this link? It is information that I must consider as a judge. And okay, here in the defense force and what, as you have seen in that particular video, that is exactly what the judge must do in executing their respective functions. Not do something else. Do that and rule on that. Or no, is it right now for the defense force to say Mangolele is convicted to imprisonment for a period not exceeding 5 years, as is the law? Remember, when we are in court, we are talking law, good people. It's only law. So in that regard, you come to this reality when our counsel humbly prays to the court to solve the actual legal problem and not torture the plaintiff with burdens of heavy penalties of cost, while the court knows it to be true that the plaintiff will never have any money unless the problem in the DOD PESOL system is resolved by the application of law decided in a public trial in a fair public trial before a competent court. It is evident that many people or judicial officers do not promote an absolute right to self-representation, but court is where all rights are protected, respected, promoted, and fulfilled. So if you chase the plaintiff away from court, consider the following. Where is equal protection and benefit of the law for the plaintiff? Why does the court not entirely protect the human dignity and life of the plaintiff as obligated by the table of non-derogable rights enshrined in the Bill of Rights? And because this particular matter is life, I will show you what the Constitution says in relation to the table of non-derogable rights and what the court must do to protect. I don't want you guys to be running away and saying, no, Mangolele is crazy, he doesn't know all these things. No. Listen to this thing. It says, it's section 35, it's state of emergency. And I will tell you about the state of emergency right now when we look for torture. The Torture Act. I will bring you to this particular section in the Torture Act. Where are we in this particular Torture Act? Let's go down. Now, when you sit and you look in this particular section, no exceptional circumstances whatsoever, but not limited to a state of war, threat of war, internal political instability, national security, or any state of emergency may be invoked as the justification of torture. That is section 4.4 of this particular act, Prevention of Combating and Torture of Persons Act 13 of that particular year. So, good people, when you understand this particular reality, where I will take you to that mix after this one. where the Constitution provides that no act of parliament that authorizes a declaration of state of emergency and no legislation enacted or other action taken in consequence of a declaration may permit or authorize indemnifying the state or any person in respect of any act or any unlawful act. Any derogation from this section, and I want to point out that this is the only section that says, yeah, you do not derogate from me as the Constitution. And then any derogation from a section mentioned in column 1 of the table of non-derogable rights, this is a section mentioned in column 1, you cannot derogate from this. And then to the extent indicated opposite that section in column 3 to the of the table, in column 3 of the table. Section 10 deals with human dignity. The extent to which the right is protected is entirely protected. And then as Lieutenant Commander Mangolele, a senior officer in the South African National Defence Force, I am compelled and then forced to live without dignity. People find each and every reason not to entirely protect my human dignity, while they actually do the opposite of what is required by law. That is why I say equal protection. And why does the court not entirely protect the human dignity and life of the plaintiff? The right, protect the right to human dignity and right to life. To life of the plaintiff as obligated by the table of non-derogable rights enshrined in the Bill of Rights. This table is enshrined in the Bill of Rights, good people. So don't say I'm asking questions that are not there in accordance with the Constitution, or anything of that particular nature. I want you to understand the true reality of this. Why must it only be corrupt people that are being protected by the law? To what end will the court refuse to operate in accordance with the Constitution and the law when it comes to the plaintiff? Where does the court expect the plaintiff to resolve this matter by application of law? What happens to criminal activity, corruption, apartheid, or misconduct that yes. Where is justice? It's unlawfully. By court to abide by the order issued on 14 September 2018, and when the plaintiff shows good cause to abide by the Constitution and the law, as is the case, to amicably resolve the matter by the application of law at first instance as obligated in Denso. Hey, Rata Pina, eh? I love this song. In oh wait, justification for torture. Perpetually invoked in expressio vari. Sanangal yo na expressio vari chini. Add this one, yeah. Dictionary crazy of people, yeah. In expressio vari. This thing, it's a Latin phrase called in suppression of the truth. You think I don't know it? I know it. Oh, let me Google it for you. Take it. Let's go Google. Yeah. Oh. I eat this one. Sure. He doesn't know these things. In suppressio vari, man. Expressio vari, suppressio vari. Which one? Oh, concealment of the truth. Suppressio vari. No, but that's why you call, but you understand concept, yeah. Suppressio vari. There is no pronunciation of the master. Where are you? Suppressio. Suppressio. Double pre. Add. Okay, now you know it. Now you cannot forget it. If you forget it, you did not learn it properly from me. Where's question now? Where is justice for all when the plaintiff is unlawfully? Let's pause you, Hanyane. We'll come back to you. I just want to go to one of my very old mixes, the hard road. So I'm just showing you all these things, how we work, yeah. It's the law dictionary again. Law dictionary. Me, I am doing this thing now. Where is it? And you come and say, where is justice? Where is justice for all when the plaintiff is unlawfully compelled by court to abide by the order issued on 14 September 2018? And when the plaintiff shows good cause to abide by the Constitution and the law, as is the case, to amicably resolve the matter by the application of law at first instance as obligated in terms of Section 21B of the Vexatious Proceedings Act, justification for torture is perpetually invoked with impunity in suppressio veri by the court itself. And does the notion of ensuring that corruption is not reported by the plaintiff, does the notion of ensuring that the corruption is not reported by the plaintiff in the interest of justice or a few in power who have committed criminal acts against the plaintiff? Is it a good example to show the Republic that people who report corruption must suffer at the hands of the law? Who will play the role of the upper guardian of the children's rights for Nyiko Mangolele and Aluta Songelwa if their father is unlawfully and intentionally not allowed to fulfill the obligations imposed on him as a parent? What does Nyiko Mangolele and Aluta Songelwa eat while their father is forced to believe lies that he was heard or granted an opportunity of being heard on 14 September 2018 by Davis J? Why does the judiciary fail to uphold the obligation imposed in terms of Section 21C of the Vexatious Proceedings Act and at any time rescind or vary the order made without hearing or granting the plaintiff an opportunity of being heard? Why must the court be happy to see a South African suffer the irreparable harm suffered by the plaintiff who is simply reporting corruption? How will corruption be solved in our country if people are unlawfully and intentionally discouraged by the court itself to report it? Does this mean corruption is the supreme law of our country, or is it a lie that the Constitution is the supreme law? Why must the court force the plaintiff to obey a manifestly illegal order while Section 1996 of the Constitution, read with Section 2E of the Defense Act and the Code of Conduct for Uniform Members of the SANDF, obligates him not to obey a manifestly illegal order? Why must the court operate opposite to the Constitution? The grounds for the review by a full bench are the following. absence of jurisdiction on the part of the court, interest in the cause, bias, malice, or corruption on the part of the presiding judicial officers, gross irregularity in the proceedings, and the admission of inadmissible or incompetent evidence or the rejection of admissible or competent evidence. The matter was not heard on 26 August 2021 at 11:30. Only case number that now you must come out. Case number 15141 of 2018 was briefly heard as responded attached here to marked SVM 27. However, misrepresented as attached here to marked SVM 28 and explained on video available on the following link and or this link. Section 1951G of the Constitution imposes an obligation that public administration must be governed by the democratic values and principles enshrined in the Constitution, which includes that transparency must be fostered by providing the public with timely, accessible, and accurate information. And when you look at SVM 27 right now, we are at page 4. SVM 27, what is SVM 27? SVM 27, ladies and gentlemen, is this particular attachment where the email was attached. It's attached where it says, as per yesterday's hearing, judge said that she will communicate with you yesterday, but judge will communicate with you next week. Kindly acknowledge receipt of this email. That was on 27 August by the judge, and then it was Chantel Andrews, a registrar to the Honorable Miss Justice Mangu Lockwood, and then my apologies for that, Advocate Titus acknowledged and confirmed the receipt. I acknowledge receipt of the email and thanked the registrar. And then SVM 28. Now the misrepresentation here is on this email. The court talks about this particular case number, and on this email the court talks about this particular case number, where it says, I have attached the order again, kindly acknowledge received, kind regards. And then apparently the order was sent before, but then in sending such an order we could not find it, myself and my learned friend, in this particular regard. So there is where I've acknowledged receipt of the email. That was yesterday after on the 7th of September. Yes, yesterday. So that is SVM 28, and then this is the application where the judgment came out. The judgment by the Honorable Mangu Lockwood. She's admitting to be judging that particular case number, and then that particular case number is not the case number of this respondent. It differs with the actual case number where these respondents are called. So immediately when you identify this case number, we take it that you are talking about the DNA of this particular issue, not, and then it needs to be represented in accordance with the actual parties involved in the case. So going forth, page 4, here we have a link which tells you, okay, South Africans, I greet you all. And once again, I am humbled to be addressing you in this particular platform. And then I would like to take you quickly to what has happened in the Western Cape High Court in relation to the matter that one was waiting for the whole week last week. So, without wasting any further of your time, one has received an email yesterday from the court, and then such an email had a court order, and then I will take you step by step for this particular matter and then give you exactly what had happened in this particular regard. So the court order is as it appears in front of you right now in the High Court of South Africa, Western Cape Division, Cape Town, case number 19275 of 2020, Cape Town, Wednesday, 31 August, before the Honorable Miss Justice Mangu Lockwood. Then it was written at this party. The parties are myself as the applicant, and the Minister of Defense, the first respondent, the South African Human Rights Commission, the second respondent, the South African Broadcasting Corporation, the third respondent, the SLC Propriety Limited, the fourth respondent. Order delivered via email 31 August. So now, before I take you to the order, I just only want you to see something. This is an appeal that was lodged. The case number to the appeal is 15141, and the respondents are in this particular form. Look at this. The case number there is not as per the appeal. You understand? In fact, this particular case number is not talking to this respondent. This case number is talking to all these particular respondents, because the case number 19275 of 2020 is all these respondents, including the National Prosecuting Authority as the third party. Now, we are having a reality where we have a misrepresentation, and effective immediately, every single thing that would be said henceforth is unlawful, unconstitutional, and invalid. That is what you need to understand. Because to waste your time and then say, hey, we can now continue and past begin, is basically to waste whatever people's time. So get good people. The reality is that this is what had happened, and then this is the first thing that one needs to sort out before we go anywhere else. Misrepresentation is serious. Remember that one is currently sitting at home without a salary simply because of misrepresentation. Do not take things lightly and then think that everything is okay while everything is not okay. Misrepresentation, it is unlawful, unconstitutional, invalid. And good people, I want to share with you what the judge has said and what, but it will be wasting your time, and then it will be scaring you, and then whatever that the judge has said, to be honest with you, is not good, even if it was good, because this is done in my name, and I am doing things in accordance with the Constitution and the law. This is what must be corrected. I must not be misrepresented. I must not be lied about on my name. It starts there, it ends there. Simple as that. So, fellow South Africans, I am busy having the matter constitutionally reviewed, and then I will set it down, requesting the Judge President or the Deputy Judge President of the Western Cape High Court to grant a full bench to hear the matter. I'm tired of listening to one judge who fears the other judge who is unable or incompetent to say yes, Mangolele was there and 14 September 2018, yes or no, he was not there. The reality is, this particular matter, as you all know it, is that the first point that needs to be proven by the state is whether I was heard or granted an opportunity to be heard before the matter was the order could be granted. Let's not dilly-dally. Here is the Vexatious Proceedings Act. Whether after hearing that person or giving him an opportunity of being heard, only then would the court order that the proceeding shall be as it is ordered. This is the key point. This is talking in terms of the Constitution and the law. This is the law relating to vexatious proceedings, and then that is exactly that. Now, given this particular reality, you would know me not to waste any further time in relation to what needs to happen. I am busy writing for this particular case number that is being misrepresented in relation to its defendants or respondents. I am saying to the court that, listen, the matter was not heard on 26 August at 11:30. Only case number 15141 of 2018 was briefly heard as represented, attached here to marked SVM 27. However, misrepresented as attached here marked SVM 28. When we go to SVM 28 and SVM this thing, I am accurate, good people. SVM 28, 27 is this when the court sent this particular email and said, as per yesterday's hearing, judge shall said that she will communicate with you yesterday, but judge will communicate with you next week. You see what the judge was going to communicate about next week in this particular regard. So these are the things that one needs to take into account. That is SVM 27. And then it is now misrepresented as SVM 28, where it is now case number 19275 of 20. You understand the same thing that I have shown you and stuff like that. And with it as it is, I am saying the plaintiff has constitutional guaranteed to just administrative action, whose source is section 33 of the Constitution, which provides that everyone has the right to administrative action that is lawful, reasonable, and procedurally fair. Procedurally fair, it brings us back to this particular procedure, the Vexatious Proceedings Act. Is this procedure, was this after hearing that person or giving him an opportunity of being heard? Is it being done, yes or no? You find that it is no, because I was not present in Cape Town on 14 September 2018. I was in Pretoria. So it doesn't matter who I was with in Pretoria or what matters is what the law says. If the law says that person must be heard or giving him an opportunity of being heard, that is what must happen. It must be done by all people, regardless of race, color, gender, ethnicity, culture, or sexual orientation. That is what they must do. You get what I'm saying? So without wasting your time, I have said that this is a constitutional obligation. I'm teaching you this such that you know how these particular things are done, and then what am I referring to, and then what informs this particular papers and stuff like that. So quickly, in terms of section 33 of the Constitution, it is exactly as it is, and you cannot redefine the words of the law to your own choosing. You must say the words of the law the way they are. You don't do your own thing. Just administrative action, it is that. You understand? Let's come to this just administrative action. Yebo, where are we now? Come here. So when you look into this particular thing here, this is what happens. Everyone has a right to administrative action that is lawful. Everyone has a right. It's direct copy and paste. Remember, I'm acting in accordance with the Constitution and the law. acting in accordance with the constitution and the law, it is exactly what you must do. So national legislation, everyone has a right to whose rights have been adversely affected by administrative action has the right to be given written reasons. And national legislation must be enacted to give effect to these rights and must provide for the review of administrative action by a court or, where appropriate, an independent and impartial tribunal. Impose a duty on the state. The state in this regard is the first defendant. You understand? Impose a duty on the state. There is the state, your first defendant, and then to give effect to the rights in subsection 1, 2. The state must give effect to these particular rights. Procedurally fair issue, and then written reasons when your administrative action has been done. But before we go to the written reasons, we get to the procedurally fair issue. So that in its own, it has on these grounds that the deputy judge president or judge president are humbly requested to direct a full bench to review administrative action adversely affecting the human dignity of the plaintiff, to provide as a father to Nyiko Mangolele and Aluta Songelo, provide as head of the Mangolele family, and as a son to the 83-year-old later Kukunana Majila. The grounds for the review by a full bench are the following: absence of jurisdiction on the part of the court, interest in the cause, bias, malice or corruption on the part of the presiding judicial officer or officers, gross irregularity in the proceedings and the administration of admissible or incompetent evidence, or the rejection of admissible or competent evidence. Like when you are rejecting admissible evidence, it's like you are rejecting the fact that I am telling you that in accordance with this particular thing, there is, after hearing that party, this is admissible evidence. And now when for me to be caused to review this particular matter is because you are not taking into account the admissible evidence. You are taking into account what any other person wants to say about Mangolele. Hey, he's vexatious. And vexatious people, it means that a person has instituted legal proceedings against any other person without any reasonable ground. You understand? You must learn to read the law and its meaning without any reasonable ground. So now, is it true or unreasonable for one to be confined into a space where you are living under these particular conditions as explicitly set forth in this particular picture? So you basically don't have any reasonable grounds to say, I want to get out of this particular picture. And to make sure that you maintain, you stay in there, let me, for crying out loud, show you the court order on this particular effect. It says, order. In the circumstances, the following order is granted. The urgent application of 26 August 2021 is struck off the roll for failure to comply with court order 14th September. You see now, when they say comply with 14th September, that means you must agree that you were present on the 14th of September in Cape Town. That's why you must comply with it. You understand? It's like here reason does not act, and then people forget that one is in a position where they cannot obey a manifestly illegal order in any event. That is as constitutionally mandated and also lawfully obligated in terms of Section 2E of the Defense Act and the Code of Conduct for Uniform Members. The applicant is ordered to pay cost of this application on attorney and client scale, and furthermore, the applicant will not be allowed to sue in this court as per Court Order 14 September 2018, and he will only be allowed to sue in accordance therewith and after paying the cost of this application as per para B above. And now, good people, that is my Judge of the High Court and Mandu Lockwood, who says that who basically gave effect to this adverse administrative action. There are many things that she's saying here about the Constitutional Court, where we now being dragged to that matter where the the Chief Justice has judged himself. But I will address this particular judgment paragraph by paragraph. But currently what needs to happen is the interlocutory order that needs to be heard by the High Court in terms of its prayers explicitly set forth on court record. So, to cut this whole thing short, fellow South Africans, it is that the order by the Honorable Mandu Lockwood is unlawful, invalid, and unconstitutional. So, without any further ado, let the law take its course in that particular regard. I thank you, Papa O Teng. God bless you. Thank you.
Wake-up calls, double shifts as a single parent, and 50-hour weeks just to stay afloat. Let's make it count.
So, it's really bad. It's finished. It reminds me of my son. I'm sorry. My apologies for that. I was just only out of office a little, having to answer nature's call. And the other thing is it's a bit cold here. But that is basically the video link that we were looking at, and then simultaneously that video link is the same as this one. It's just that it only appears on Facebook. So this matter is done to cater for all other people that do not have Facebook accounts or anything like that. It is the same thing. And then that talks about, I must not be misrepresented. You see, so you would understand that to be true in this particular reality. Further, the matter is not heard since it was issued on 30 December 2020. This is when I show you that to come here, to come to this link, it is the same video. Sorry, it was a mishap from my side, where one employs their rights in terms of section 16. Here is the vexatious proceeding showing whether after hearing that person or giving him an opportunity of being, this is statute. So you would understand that it was done for those who do not have Facebook. It's the same thing, and or. That's why these explicit terms comes into play. Sorry. Further, the matter is not heard since it was issued on 30 December 2020 only to sustain or support criminal activity, corruption, apartheid, or misconduct with the unqualified intention to delay our democracy and or subject all South Africans into slavery, to live and struggle, strive, or attempt for freedom in their land. The plaintiff was tortured with unlawful detention from 21 January to 28 June 2021 based on allegations of trespassing, only to ensure that this matter is not heard in accordance with its terms, and is unlawfully and intentionally deprived of his fundamental human rights enshrined in the Constitution. Article 6 of the Universal Declaration of Human Rights, read with Section 20 of the Constitution, mandates that no person may be in situ persona non grata. In situ persona non grata, it is something like this. Let's verify it again openly before all the people. Person not welcome. And then let's say in situ. In the natural or original position or place, that is in situ persona non grata. Yes, so in that particular Latin phrase, I think I pass. The plaintiff has a constitutional guarantee to just administrative action whose source is Section 33 of the Constitution, which provides that everyone has the right to administrative action that is lawful, reasonable, and procedurally fair. Everyone whose rights have been adversely affected by the administrative action has the right to be given written reasons. National legislation must be enacted to give effect to these rights and must provide for the review of administrative action by a court or, where appropriate, an independent and impartial tribunal. Impose a duty on the state, which is the first defendant, to give effect to the rights in subsection 1 and 2 and promote an efficient administration. The relief sought is an interlocutory and or mandament fanspoli remedy, following a spoliation in which the defendants took the law into their own hands and resort to self-help instead of using due legal procedure. And on a balance of probabilities, the plaintiff, the Republic of South Africa, and its people continue to suffer irreparable harm if the court does not so order, and that the defendants will not suffer irreparable harm if the court so orders, as envisaged in terms of Section 18 of the Superior Courts Act. I want you to remember that this particular matter is in terms of Section 18 from its inception. So I've just read you Section 33. I said the upper guardian of the children's rights is in terms of Section 33 of the Constitution, read with Section 18 of the Superior Courts Act and Section 64 of the Children's Act. It's just that with court proceedings you would want to tend to conceptualize all things under one concept and then exhaust that particular concept and finish it. If you want to talk about your teeth, for example, you will talk about legislation that regulates your teeth and everything that has to do with your teeth. That is why in this particular document it is set such that all things follow into play. I remember when I was at Naval Staff College, we were taught to maintain the golden thread. Do not go talk about that part there and then talk about that part there. They must follow a thread that is chronological in order. You understand? And then if you follow this particular trend of thread, then you would understand exactly what one is writing. I'm stuck into the terms of the Constitution and the law as obligated. The dice indica in terms of Section 18 of the Superior Courts Act is 2 hours, as obligated by the practice by practice directives issued by the Chief Justice. In terms of Section 18(1) and 2 of the Superior Courts Act, the operation and execution of the court order to case number that is suspended pending the fundamental decision by the Honorable Miss Justice N. Mangu Lockwood as to whether or not the plaintiff was heard or granted an opportunity of being heard by the Honorable Davis J. before the order on 14 September 2018, and grant a just and equitable order in terms of Section 21C of the Vexatious Proceedings Act as prayed for in the notice of motion. In any event, the court shall find that the plaintiff has shown good cause in terms of Section 18(5) of the Superior Courts Act, lodge leave to appeal or a notice of appeal with the registrar in terms of the rules, and the appeal in terms of case number 15141 of 2018 is not opposed by any party, not to be granted in terms of Section 21C of the Vexatious Proceedings Act. Section 21C of the Vexatious Proceedings Act provides that an order under paragraph A or B may be issued for an indefinite period or for such period as the court may determine, and the court may at any time on good cause shown rescind or vary any order so issued. With what more suffering must the plaintiff, his children, family, country and its people go through for any erudite judge to rescind the order issued on 14 September 2018 as obligated in terms of Section 21C of the Vexatious Proceedings Act. An Act of Parliament in terms of milestone 1 of the South African Defence Review 2014 obligates arrest of the deadline and critical capabilities through immediate directed interventions. In exercising any power or performing any duty in terms of the Defence Act, the plaintiff is obligated in terms of Section 2A of the said Act to have regard of the principle that the formulation and execution of defence policy is subject to the authority of Parliament and the National Executive. It is well understood that this matter affects other judicial officers personally as a result of the people involved. Counsel takes liberty to remind the Deputy Judge President or Judge President that Article 12(1)(a) of the Code of Judicial Conduct provides that a judge must not belong to any political party or secret organization. There is no secret that the Honorable Davis J. made a fundamental error by not hearing the plaintiff or granting him an opportunity of being heard before making an order on 14 September 2018 in terms of case number 15141 of 2018. Equally so, it is also not a secret that the Honorable Mangu Lockwood J. has erred to represent the parties of case number 15141 of 2018 as the parties to case number 19275 of 2020. Both these judges are equal persons before the law, and their act or omission must not be used to torture the plaintiff or punish or treat him in a cruel, inhumane, or degrading way so as to unlawfully and intentionally protect or support criminal activity, corruption, apartheid, or misconduct, and a secret belief that any person representing themselves will not win in court. As of paramount importance to the upper guardian of the children's right, Niko Mangolele and Aluta Songelwa are the plaintiff's children, whom all organs of state in any sphere of government and all officials, employees, and representative of an organ of state must respect, protect, and promote their rights contained in the Children's Act as an obligation imposed in terms of Section 8(2) of the said Act. The plaintiff's children suffer irreparable harm, and the upper guardian of the children's rights must protect Niko Mangolele and Aluta Songelwa from maltreatment, neglect, abuse, or degradation sustained by non-payment of salary for the past 36 months as a result of the making on the DoD PESOL system on 8 August 2018, an unlawful and intentional misrepresentation that causes actual or potential prejudice to the plaintiff, his children, family, country, and its people. Misleading all people to believe that the plaintiff is convicted to imprisonment for a period of 5 years subsequent to a charge of offensive behavior in terms of Section 105 of the Defense Act, unlawfully or falsely entered as a reason for the alleged administrative discharge of the plaintiff. Section 6(4) of the Children's Act imposes an obligation that in any matter concerning a child, an approach which is conducive to conciliation and problem solving should be followed, and confrontational approach should be avoided, and a delay in any action or decision to be taken must be avoided as far as possible as obligated in terms of the Children's Act. Even if any person maliciously persecutes the impecunious plaintiff, as is the case, the plaintiff is unlawfully and intentionally continuously caused to live his life as if he was heard or granted an opportunity of being heard before the Honorable Davis J. made the order on 14 September as unlawfully and intentionally made to misrepresent the statutory terms of Section 21B of the Vexatious Proceedings Act. Any other argument presented does not hold the force of law in the event that the plaintiff was not heard or granted an opportunity of being heard before making an order on 14 September 2018. Therefore, to keep on admitting all constitutional attempts by the plaintiff to, in terms of the principle of Patupeli and the spirit of Ubuntu, sought redress in accordance with the Constitution and the law as obligated in terms of Section 1995 of the Constitution, must not be seen as punishment, or that the plaintiff has persistently or without any reasonable ground instituted legal proceedings in any court or in any inferior court, whether against the same person or different persons. To act in accordance with the Constitution and the law in service and defense of the country and its people with honor, dignity, courage, and integrity does not only limit the security of the Republic to one, but all organs of state at any given time to protect the Constitution, the territorial integrity, and national sovereignty of the Republic and our democracy. The Deputy Judge President or Judge President are humbly requested to, in terms of the preamble of the Constitution, as the people of South Africa, recognize the injustices of the plaintiff's past, which includes the recent past malicious prosecution unlawfully detaining him at Pollsmoor from 21 January to 28 June 2021. Honor him for suffering for justice and freedom in our land, causing all to live and enjoy freedom in the universe, our home. The plaintiff has worked to build and develop our country and believe that South Africa belongs to all who live in it, united in our diversity. As obligated by the preamble of the Constitution, the Deputy Judge President or Judge President are freely elected representatives through which the plaintiff adopts the Constitution as the supreme law of the Republic so as to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. Lay the foundation for a democratic and open society in which government is based on the will of the people and every citizen is equally protected by law. Improve the quality of life of all citizens and free the potential of each person, and build a united and democratic South Africa able to take its rightful place as a sovereign state in the family of nations. The posture of the court to set impossible and or unreasonable conditions that are aimed at maintaining criminal activity, corruption, apartheid or misconduct in the SANDF. Excuse me, let me take this call, please. Mangolela, hello?
This is an important consumer announcement.
Okay, no, not now, thank you. Hey, it is pay as you go. Sorry for that also. The posture of the court to set impossible and or unreasonable conditions that are aimed at maintaining criminal activity, corruption, apartheid or misconduct in the South African National Defence Force adversely affect the life of the plaintiff, his children, family, country and its people. And in any event, the courts have in the past refused to resolve the dispute in the DOD PESOL system by the application of law. Counsel therefore pleads with the Deputy Judge President or Judge President to grant a full bench that can resolve the dispute in the DOD PESOL system by the application of law decided in a public hearing before in a fair public hearing before a court as obligated in terms of Section 34 of the Constitution. When applying a provision of the Bill of Rights in the terms of Section 8 of the Constitution to the plaintiff as a natural citizen or juristic person, the court must consider the following unique factors that in terms of Section 62L of the Defence Act define the soldiering profession. The plaintiff is a national asset which is mandated under the Constitution to be structured and managed as a disciplined military force and in accordance with the principles of international law governing the use of force. The plaintiff is essential in the defense of the Constitution, the territorial integrity and national sovereignty of the Republic and our democracy. The plaintiff's inalienable right to life, which is guaranteed in the Bill of Rights of the Constitution, is entrusted to the nation and the state. It is an unavoidable reality that the plaintiff's family is part of the larger Defence Force family, as an institution to share in the joys, anxieties, and the sometimes unfortunate outcomes of service, including maiming and death. It is therefore necessary to create a working environment for the soldiering profession that is positively conducive to discipline. The plaintiff is tortured, while there is indeed a constitutional guarantee that everyone has a right to freedom and security of the person, which includes the right not to be tortured in any way. And in any event, all constitutional obligations must be performed diligently and without delay as contemplated in terms of Section 237 of the Constitution. Notwithstanding that the plaintiff is accountable to all more than 60 million fellow South Africans, the plaintiff leads tens of thousands of subordinates in the South African National Defence Force, and is the last line of defense when all organs of state fail, and is obligated in terms of Section 1996 of the Constitution, read with Section 2E of the Defence Act and the Code of Conduct for uniform members in the SANDF, not to obey a manifestly illegal order. The founding affidavit of this matter at para 18 on page 39 boldly advances that the strategic outcome-orientated goal 1 of the Department of Defense is that the Republic of South Africa is defended and protected. This outcome encompasses the central purpose of the Department of Defense and includes the following 3 main elements. Comprehensive defense capabilities are enhanced and maintained. Peace, stability, and security in the Republic of South Africa, region, continent, and world are promoted. The people of South Africa are supported. As a juristic person, the plaintiff is security of the Republic. This matter includes imprisonment of the incumbent President Cyril Ramaphosa and other defendants in terms of Section 4 of the Prevention of Combating and Torture of Persons Act. Number 13 of 2013. The national anthem is prayed at any time by any fellow South African anywhere in the world and is an imposed constitutional obligation and directly affects the best interests of all children. Diligence is in terms of Article 10 of the Code of Judicial Conduct, obligating any judge, obligating any judicial officer to perform all assigned judicial duties diligently, give judgment or any ruling in any case promptly and without undue delay, not engage in conduct that is prejudicial to the effective and expeditious administration of justice or the business of the court, and take reasonable steps to maintain the necessary level of professional competence in the law. Any judge in the Western Cape Division has sworn or solemnly affirmed that as a judge of the High Court will be faithful to the Republic of South Africa, will uphold and protect the Constitution and the human rights entrenched in it, and will administer justice to all persons alike without fear, favor, or prejudice, in accordance with the Constitution and the law. The court must be true to these terms. All I ask is for case number 19275 of 2020 to be heard in accordance with its terms before a full bench. The fraudulently obtained court order to case number 15141 of 2018 is unlawfully and intentionally used to block the judiciary from ending criminal activity, corruption, apartheid, or misconduct in critical capabilities, and indemnify the state or any person in respect of any unlawful act against the plaintiff, his family, country, and its people. All efforts are engaged upon by other judicial officers to force the plaintiff to agree that he was heard or granted an opportunity of being heard by the Honorable Davis J. on 14 September 2018 before making the order to case number 15141 of 2018 must come to an end. Because the reality is that the plaintiff was never heard or granted an opportunity of being heard before making an order, which misleads all people to believe that the plaintiff does not have fundamental human rights, which includes equal protection and benefit of the law enshrined in the Bill of Rights. To the registrar, kindly set down the matter in accordance with the direction of the Deputy Judge President or the Judge President in terms of Rule 612A. Of the Uniform Rules of Court. Then you go there. There he goes, there he goes. Yowie, 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 yowie. There. Ish. Okay, let's do this. Are we done? We are done. Good. Excuse me. Hey, having a live office and fostering transparency, it's another story. So, fellow South Africans, this is the issues of the court, and I'm going to save this like this and say save as. It's in a Cape High Court matters. It's a notice to third party and set down a full bench. Okay, it's fine. And what is missing now in this reality? Okay. If I may add that this matter was publicly administered to foster transparency to foster transparency by providing the public with timely accessible and accurate information in order to fulfill an obligation and impose in terms of and 5.1 G of the Constitution. And I want you to calm down, please. Up 5 and you're fine, you're fine, you're fine. Be good, be good, be good, on point, on point, on point. So, fellow South Africans, this is how this thing is basically done. I am showing you how it's done. I am showing you all my efforts. I am showing you how crazy I am being driven with this regard. And I do this, all of this, in accordance with the Constitution and the law, as you have come to see, and then as you have learned, and as may be viewed. Let's view, let's give him a view. And then the link, where is this link? Oh, Jesus Christ, my demo. Okay, but I will have to do this particular thing, because in doing this thing you will see that now this whole document is done, and with it being done, everything that I've been saying to you is basically what the court will be hearing, and then the court must apply its mind in terms of the Constitution and then resolve this particular matter. And I must do a court order to this effect, and a draft order. And let me do this to this too also. Yep. I think we're cool. The link must follow here to prove this particular issue. link. Alright, now let's see this particular link, and then let's give it time here. What is for the happening? What is happening? What is happening? What is happening? So, fellow South Africans, that is how we have been doing this particular thing. This is what I have been doing. I just only want to end this particular stream, and then in ending it I will come back because I require the link to it, and then in requiring that link I must also duplicate it in YouTube so that the persons that do not have Facebook can also view it on YouTube, and then there is no excuse by any other person that they did not see the link. So let me just break this video, and then I will come back with another video just promptly, quickly now, because I must do this admin before 3 o'clock today. Thank you. God continue to bless you. Papa O Teng.